For many years, we have argued that some of the finest experts on the rights of indigenous peoples are indeed to be found among our own collectivity. We are genuinely pleased and encouraged to see our deeply felt view reflected on the podium here today. Mr. Chairperson, we believe that it is of crucial importance that the expert mechanism immediately established an efficient working relationship with the Human Rights Council and its members. This working relationship must allow the Human Rights Council, in conformity with its Resolution 636, to assist the expert mechanism in relation to the issues of the topics that the Council requires input and advice upon from the expert mechanism. However, at the same time, the Council must allow the members of the EMRIP, in their capacity as recognized experts on indigenous people's human rights, to exercise substantial influence over the issues that the EMRIP should review, as well as to guide and prioritize its work. In other words, we hope and trust that the circumstances under which Resolution L17 was adopted was an exceptional case, prompted by the fact that the EMRIP had not yet held its first session. The Arctic Caucus presumes that the Human Rights Council will receive the first expert mechanism report on the subject issue identified, but that they also demonstrate both flexibility and willingness to cooperate on future issues deemed to be of substantive priority or of an urgent nature by indigenous peoples. We are prepared to work closely with the HRC, both now and in the future, in an effort to ensure that HRC allows the EMRIP to constructively address the issues of greatest importance and concerns to indigenous peoples. It is through direct engagement, discussion, and collaboration with all parties concerned, and in particular indigenous peoples, that will ensure the success of the EMRIP. Furthermore, such collaboration will generate greater probability that the Human Rights Council will take the EMRIP's conclusions on indigenous human rights issues seriously. Such a working method and understanding is in full conformity with Resolution 636, paragraph 1, interpreted in a flexible way and we believe comparative manner. Mr. Chair, in accordance with the United Nations General Assembly Resolutions 61295 and the spirit and the text of the Human Rights Council Resolution 636 and L17, it is clear that the legal basis and framework for all the work of the EMRIP must be the United Nations Declaration on the Rights of Indigenous Peoples. We are fortunate to have the declaration, as it provides a comprehensive framework for the review and norms and how they are manifested within our respective societies, as well as within the larger societies that surround our peoples, nations, and communities. As each member knows, the declaration provides the necessary benchmarks or minimum standards by which the realization, exercise, and enjoyment of indigenous human rights must be measured. When indigenous persons or our communities fall below these minimum standards, the world community, through the Human Rights Council and other organs and agencies of the UN, must act and act decisively in favor of the disadvantaged. In our distinct context, we are of the firm belief that there is a crucial link between the minimum human rights standards of the Declaration and the Universal Periodic Review of the members of the Human Rights Council. We urge both the expert mechanism and the Human Rights Council to be mindful of the linkage and to maintain their purpose and integrity by acting accordingly in the preparation of their respective reports, reviews, and recommendations. In regard to potential thematic studies, the Arctic region encourages the expert mechanism to consider ways in which they can assist the world community and the Human Rights Council specifically in avoiding and resolving conflicts that may inhibit the exercise of the right of self-determination by Indigenous peoples. As the members of the expert mechanism are well aware, the exercise of the rights of Indigenous peoples to self-determination is a prerequisite to the exercise and enjoyment of all other human rights, including those contained in the Declaration, as well as other international human rights instruments. The Human Rights Council should not underestimate the valuable contribution that the expert mechanism can make in this crucial area. Another suggestion of the Arctic region is to pursue a thematic study in the matter of Indigenous customary law. We are aware of the fact that a number of important international and national entities, including CPD and the WIPO, are elaborating instruments that are direct relevance to this specific topic. Therefore, it would be timely for this body to provide a comprehensive human rights-based approach to the subject matter in order to ensure that the respective standard setting and policy development of these entities emerges in a fashion consistent with the standards affirmed in the Declaration. Such a thematic study would also be consistent with the mandate of the expert mechanism and the interdependent, indivisible, and interrelated nature of human rights. In this way, the worldviews and perspective of Indigenous peoples in relation to their customary laws, institutions, values, and practices can better inform the evolution of standards at the CPD, WIPO, and elsewhere. Though the mandate may appear limited, we have confidence in the ability, creativity, and capacity of each member of the expert mechanism to carry out their work consistent with the substantive and procedural aspects of their mandate, as well as their aspirations and fundamental human rights of Indigenous peoples worldwide. I thank you, Mr. Chairman.